Hello and welcome back to the show Conversations with Candidates. Today we have on here District Attorney candidate James O'Shea. Thank you for coming on the show.
Thank you for having me, Danny. Really appreciate it.
Yes, of course. So you mind just tell the voters a little bit about yourself?
Sure. I'm running for District Attorney of Essex County. I was born and raised here in Lynn. I have had a law practice for the past 24 years. The first 7 of those years I was on my own. For the last 17 years I've been practicing with Morris and O'Shea with my partner attorney Helene Morris, who is an immigration expert. I've decided to run for this. Part of my practice has always been here in my hometown in Lynn. I've been a bar advocate for 24 years, serving the indigent community, people less fortunate, the voiceless, as they're sometimes referred to, and that's been extremely rewarding. I've decided to run for district attorney so that I can go from using my experience, seeing what works and what doesn't work within the court system, and applying that in policy for justice for everybody. Right now I've been serving people basically one at a time, and I think I have some really good ideas based on my own practice to be able to apply the policies that will serve everybody and fix the things that I think are not working so well.
Awesome, great. And what do you believe is the job of the DA for the 34 towns and cities in Essex County?
Sure. The ideal for every DA is to balance public safety with the interests of justice and to protect uphold the constitutional rights of all the people that come through the justice system. And that's the ultimate goal for anybody, is to balance those two things. I have the ability to do that because I've seen how it works and when it's not working. And I can script certain policies in particular that I would put in place in order to do just that, to balance the two. I think in Essex, in particular, we've gotten a little out of whack on the public safety side. We've gone a little too far, and we need to balance back some of the interests of justice.
Mm-hmm. Great. And what are the top 3 issues you would wish to tackle as DA if elected?
One of them deals with that balance. Right now, if you look statistically, Danny, we're filing in Essex County way too many 58A dangerousness hearings. Mm-hmm. Okay, the studies show that we're filing more in Lawrence alone, and what those 58As are is they're motions by the Commonwealth to hold people without bail based in part on the nature of the charge and not on the facts and circumstances of the case. And that's wrong. We have a disproportionate incarceration of people of color and Latino people, I think, in part because of this policy. And so right away, that would be something that I would change. The other thing that I would change is the district attorneys in the session, the ADAs that would work under me, are held to almost a paint-by-numbers approach that is dictated in part by the nature of the charge. Again, not taking into the facts and circumstances. One of the greatest challenges for any district attorney in any county is trying to retain top talent. These are dedicated professionals, and they work for less money. So you have to make than they would get in the private sector. So you have to make the job more attractive to them. One of the ways you do that is to increase their discretion in making decisions on their cases. Right now, I think there's just a little bit too much control from the main office. And so that would be something I would change. I would make the job more palatable, more attractive to them by giving them the ability to make more decisions. The other thing that does for you is it gives you a better tool to evaluate them. You get a better understanding of how good of an attorney they are based on them making solid choices or not making solid choices. So if you give them discretion, you can evaluate their performance in a different way. The third thing I would change is based on my experience in other counties. In the 24 years, I've served not just this community and the Lynn District Court, but I've been to courts all over the Commonwealth in a variety of counties: Worcester, Plymouth, Suffolk, Middlesex, all over. And most recently, I was in Middlesex. And for example, I went in there to enter an appearance, and you don't usually expect to get too much from the DAs in the session on your first appearance when you're first meeting them. Handed them a business card, Danny, and within 10 minutes, they took my email address and sent me a password-protected folder with all the discovery, with all the information that I needed, and an offer to resolve the case by way of a disposition. That doesn't happen in Essex, and the reason is that we're using antiquated technology. When I go to court in Essex, they hand me a DVD, or they'll send me an email and a PDF that's not password protected. And some of those documents and some of that information should be privacy protected. They have phone numbers, addresses, names, dates of birth. And so a lot of it's public record, but a lot of it's not. And that's something we need to deal with right out of the gate. Spend some money, update the office, and make those changes. But the first one, I think the 58A deals with a social justice component that has to be addressed.
Great. So thank you. And what would your approach be to handling the current opiate crisis that's really been taking over?
Sure. In 24 years, I've had, it's funny, we're on the campaign, not funny, haha, but funny, strange. You're on the campaign trail and you hear this question asked over and over about the opiate addiction issue. And a lot of the politicians give answers based on policy and things that they would like to see happen, but most of them don't have the real world experience that I have in working in the Lynn District Court and seeing it on the front line. So I've seen what the drug court is trying to do and has been trying to do, and they've made great strides. And I really, it's not so much a critique of the drug court. It's just trying to think outside the box and come up with a different way to attack this. The drug court, as it's presented to my clients, the voters should know, is usually presented as more of a stick than a carrot. It's more of a punishment after they complete, or don't complete, fail to complete regular probation with conditions. So what I would do is flip the script, and I would try to offer more pretrial treatment. I would say, if you can prove that you are committed to your sobriety, if you're committed to staying clean, then we're going to give you a reward at the end that won't saddle you with yet another conviction on your record that will turn you into the cycle of relapse and turn you into we want people to get back to work is what we want. So the problem with treating this post-conviction is that even the people that stay clean and sober have difficulty finding employment because they're saddled with that conviction. And it leads to another cycle. I think if you avoid that conviction in the cases where you can, you're going to have a situation where people are more employable, then they can feel better about themselves. I think they're less likely to relapse. There's more hope. They have something to look forward to and feel good about, take pride in. And I think that's the way to attack this. And I say that, again, based on having done this for a very long time and seen it firsthand. This isn't based on some policy or theory. It's based on actually seeing and representing people that struggle with this.
Great. Thank you. And how do you think that we should deal with nonviolent offenders, the cases that come through?
I think you have to take every case, not based on the charge, but based on the facts and circumstances of the charge. So in terms of nonviolent offenders, I don't like putting people into categories like that. I think on both sides we get in trouble when we decide that we're going to punish based on the nature of the charge. If you look at the facts and circumstances of every case and you treat every defendant with the constitutional rights that they're entitled to, and you take into account all the mitigating circumstances, then you'll get to the right result. But I don't believe in decriminalizing certain charges, and just like I don't believe in the 58 days of punishing certain charges with potential revocation, not revocation, but being held without bail, denial of bail. Yeah. So I think on either side, you get into problems when you start to focus on the nature of the charge as opposed to that individual's rights and that individual's alleged offense and the nature and facts and circumstances. I can give you an example. There's a huge difference between somebody that goes in and shoplifts because they can't afford food and they're stealing to feed their family versus someone who is maybe in a gang or in a situation where they know that the policy of the office is that we're not going to prosecute shoplifting, so they go and take advantage of a store owner. If you're not looking at the person and the basis for what drives them to commit the offense, I think you're doing a disservice to justice.
Mm-hmm. And kind of based off that, how would you decide which cases get top priority when you're going through them all?
I have a simple approach that's grounded in the law, and that is our system of justice is founded upon two principles, I believe. The first is we punish evil acts. So it's the intent of the actor that needs to be punished. Anyone that preys upon the most vulnerable in our society, be they the elderly, children, animals, things like that, those people need to be punished. But the second side of that coin is our system of justice is also based upon rehabilitation. So anyone that's suffering from addiction, suffering from mental health disorders, some other component that's propelling them to be within the system, to be in front of the judge in the court, will seek help for them and rehabilitation. So it's really based upon the law. The law punishes evil intent, and the law provides services and rehabilitation for people that are compelled into the system for some other reason.
And what would be, like, what are the major sources of crime you would want to focus on? Is there specific ones, or is it more general?
I wouldn't focus on any one law. My job as the district attorney is to prosecute the laws that are on the books, whatever those may be, and to punish according to the prescribed penalties. And again, to afford my ADAs the ability to evaluate and make discretionary decisions on which cases will receive more of their attention based on, again, I sound like a broken record, the nature and circumstances and the facts and evidence of the case before them. No two cases are the same, no two defendants are the same, and they shouldn't be treated that way. Everybody that comes before the court should have their case analyzed based on the facts, the circumstances, and the mitigating circumstances, if any.
And how do your qualifications put you in the best position to be the DA?
I've been doing this for 24 years. Some people say I'm in the trenches. That's one way to look at it, but I've had a wealth of experience in dealing with all different types of people from every socioeconomic, racial background, sexual preference, you name it. I've been able to do this successfully as a practitioner, and I want to take what I've learned and then put in the policies to address these issues, the very pressing issues. This isn't a situation where you can just take over the office and drive the ship and be happy with the status quo. As you've raised, we have too many pressing problems. We have the opiate crisis. We have the social justice problem with the disproportionate incarceration of people of color. These are things that need real answers and real policies to address these pressing issues within our society. And I've seen it every day as a practitioner. And I'm the only one. The only way to come up with ideas to try and solve these problems is to be in the fray and to understand what needs to change. And you can only learn that through practice. You can't get that from a book, from teaching, or from any other source. You really need to be immersed.
Mm-hmm. Right.
And also, the law changes every day, Danny. So it's not like your experience from 10 years ago is going to be applicable necessarily to your experience now, to what's happening now, to the problems, the pressing issues that are current within the court system. So it's not transferable. Mm-hmm. Give you an example. A friend of mine who was a very good criminal defense attorney changed his practice, and he became more of a real estate lawyer and a paper lawyer. So he was sending me criminal cases, and I would say to him, why don't you take these? You're perfectly capable of handling these cases on your own. And he said to me, I've been out of this for 2 years, and I'd be afraid that I would have missed something. That's 2 years. If you're out of this for more than 10 years, there's no way you can have transferable skills to the way the justice system is working right now.
Great. Thank you. And then how would you use your previous interactions with law enforcement in your position as DA as a
Sure. I'm very proud to report that I got the endorsement of the Lynn Police Association here locally. I think that speaks volumes of having worked with them for 24 years. What people don't understand is there is an adversarial system here, for sure, in terms of motion practice and trials. But a lot of it is collaborative. We're all trying to get to the best decision for all the parties involved, be they victims, defendants. We're all trying to resolve these cases, and most cases are resolved by way of plea agreements, negotiated tenders, and that involves working collaboratively with the police, with the assistant district attorneys, with the judges, with the probation department, and everyone within the court system. And again, you can only do that if you're actually practicing.
And our final question is, how would you take the vision you have for the DA position and turn it into a reality?
I think day one, we can certainly fix the IT problem, right? I would bring in somebody to update that right away. The reality of the 58 days is I would create a policy or eliminate what I perceive to be the policy of charging every potential strangulation with a 58A dangerousness hearing. We would scale that back, and I would allow the DAs to have the discretion within the court. These things that I'm talking about are ideas that you can only get practicing, but they're pretty easy to implement. And they're just policy decisions that shift to meet the times within the office. And I think my ADAs will be very receptive to receiving more discretion and making their own decisions. And I think that'll be easy to do as well. My intention is to meet with all of them once I've won the election and go over that with them individually and then collectively.
Awesome. So, thank you. I want to thank you again for coming on the show and giving the voters a little bit more about yourself.
I really appreciate that.
Of course.
Thanks so much.
You're welcome. And once again, I'm Danny Vittori. This has been Conversations with Candidates. Join us next time for another episode.